Hey everybody. So we're going to go ahead and get started. We do have some others that are going to be joining us here. We've got at least a few more in person that are supposed to be here and some more online. But I wanted to go ahead and dive in. Thank you for coming to the business workshop. This has been a really great addition to what we've been doing here at the Chamber this year. We have another one that is going to be in August that is going to be on HR and toolboxes to use for small businesses. We have a lot of events going on. I'd say look at that back wall. You can see everything going on, or go to the Chamber website, look at our event calendar because there's a lot happening this fall. But let me kick off. Thank you, Paige, for being my Vanna White. I'm going to turn it over to Paige with the Blacksburg Ballet as our sponsor.
Well, I feel like I'm in case, a nice small intimate group, which it makes me more nervous than a giant room with 2,000 people. So, hello. Great. Thanks. Hi, I'm Paige Gwynn. I own Dance Tech and the Blacksburg Ballet. So these are my people. I spend 90% of my time with children, ages 3. We do have classes all the way up through 83, but most of them are kiddos. This past year to kick off spring break, we danced at a Charlotte Hornets game and had a blast. But I'm here today to talk a little bit more about Blacksburg Ballet. So Blacksburg Ballet is our sister nonprofit organization, and basically the way that works is we primarily use Dance Tech's space for rehearsals, and we get the majority of our cast members for shows from Dance Tech, but not all. We have a lot of family members in the show. So that top left picture, we have Maddie and Willie. They got to be Clara and Drosselmeyer the other year. And you might recognize them from Sam's Hot Dogs in Blacksburg if you were a frequent customer there. We get siblings in our shows. So my top right, that's Lucas and Harper. Harper just went on. She is actually in basic training camp right now. She decided to join the ROTC in college, and they said that she made the best buns, clearly. So she was already ahead of the game. We also have local performers like the Hokey Bird. We have teachers from not only the public schools, but also our studio. So it's really all about coming together and bringing a wide range of people to perform. Our goal is to have a representation of basically everyone in our audience on stage. So it's not something that's unattainable. It's like, if I would want to be a performer, I could get up there and do it. So if you're interested, open casting September 6th. See you there. Everyone here could perform. But what I wanted to talk about is how I have gotten involved and used the chamber to further our mission for Blacksburg Ballet. So I do IFS. This is my second year. Last summer, we hosted a business after hours. There's that huge crowd up there. At the studio, and I'm gonna be honest, it was a lot of work, but it was so worth it because it was our opportunity to show what we have going on in our business in less of a presentation mode and more of a mingling mode. So highly, highly recommend that. I recorded, I think at this point, 4 podcasts with Alan, which are always really fun, and he gets the tough questions so you can share different aspects of your business or organization that you might not present when you're thinking of it. Member spotlight video, those are fun too. You can do it at your business or here. You can write blog posts and then sponsor events like I'm doing today. So I have really used that to get our name out there. And then personally, I just decide I can't do anything halfway. So caught myself there. So getting involved. Bocce ball, highly recommend. Volunteering at golf, highly recommend. Go to ribbon cuttings, lunch and learns, eggs and issues, business workshops like this. I have served as an ambassador, which if you are nervous to get involved is the #1 way to do so because you have to go and you have to talk to people. If you want to serve on committees, I've served with the Women's Leadership Conference. And my pro tip is you get to watch all of the presentations ahead of time. So we got like double the amount of presentations. So we were living our best lives. I already mentioned case groups. I've actually transferred this to one of my younger employees, which has been really beneficial for me and her because it's a almost training wheels to get someone that's newer to networking and speaking publicly, because you have your comfort zone every week and you practice over and over again. And then this year, I started serving as a dean for leadership. So if you're unfamiliar with the leadership program, look into it. We actually have class tomorrow, and it is, I'm trying to remember which day it is. Government and recreation. Thank you so much. So we get to hear from government leaders. There will be a panel discussion. We're going to the new park. Apparently, we're going to meet some animals. I'm very excited about that. And then my biggest pro tip, if you're like, this sounds like way too much work to get involved with all of this stuff, is shamelessly ask people to nominate you for awards. Because there's a little bit of work you do have to fill out if you get nominated, a submission, which is pretty in depth, but your name is put out there over and over again, all over the chamber social media, the website, at actual events. You're putting your personal name and your business name out there if you're nominated, not just if you win, even if you're nominated. So that's always my pro tip of like easy way to get your name out there. Last but not least, I want to talk about what all of that has done for Blacksburg Ballet and what we were in turn able to do for the community. So we kind of launched or built up business spotlight sponsorships in 2024 for our Nutcracker Ballet. So we had over 30 businesses and individuals decide to sponsor our field trips. And what that meant is that we were able to host actually 2,200 children and elderly to come to the Moss Art Center to see field trips of the Nutcracker, 100% free for them. And that was because of our business sponsorships and business relationships. So, bless you. Some people choose to just donate because it's a good cause. But the really fun thing we did was we got Christina Rose to photography to collaborate with us, and we went out to local businesses or brought them to us and did photo shoots. So we had our cast members like at the gym working out with the trainer, took pictures of it. It's mutually beneficial for all of us. And basically, so not only did we get to provide for the first time these field trips for free for 2,000 people, we also, because of this, had an 11% ticket sale increase from 2023 to 2024. So that is like no small feat. And basically, this stuff was on the page before, that was 1 year of work. So putting yourself out there for 1 year made that much of an increase. So I just saying, I highly encourage everyone to take advantage of everything that you can do as members of the chamber, because the possibilities are pretty much limitless, what you can do for yourself, your organization, and then in turn the community. Thank you.
I want to thank Paige for sponsoring today's program, and I want to thank Jim for being here today. We're very fortunate to have him. I'm going to read a quick bio about Jim. He is the chairman of CowanPerry Law Firm. His practice focuses on representing management in the full spectrum of labor and employment related issues confronted by employers in today's workplace, handling complex business litigation matters and representing property owners and developers on land use issues and commercial real estate projects. He represents a wide range of employers, business owners, developers in the region, ranging from high-tech startups to large manufacturers, and from local property owners to national developers. Let's please welcome Jim.
Well, good morning. Thank you guys for being here, and those of you who are here kind of virtually. We're going to do, last year we did one that was focused mainly just on kind of employment law and compliance and the things we see folks getting in trouble with. We're going to touch on a couple of those that are ones that I continue to see business owners kind of maybe the most frequently bumping into. And then we're going to move around a little bit and talk about sort of some more things on some of the corporate or business side that I thought might be useful to y'all. And certainly if you have questions or thoughts as we go along, let me know and we can jump around a little bit. This is a topic and one that's fun for me to do. Our firm, I was talking to folks here right when we got started, is, we only represent businesses and their owners. I think that's the one thing that makes us a little bit different from a lot of firms. We joke sometimes it's like the stuff we won't do for you, right? So we come in and we have good clients all the time that represent their company. They're like, we're buying a house. Can you handle my closing? No. Right. So, we don't do that. We don't do domestic. Get a traffic ticket. Don't call me when you get arrested at 2 a.m. But, I know who to call, but it's not me. But anyway, but a lot of what we do is what's considered outside general counsel work. And so our goal in our relationships with our clients. We do certainly just project work for folks, but is to become a partner with them and essentially be their legal department for groups that are anything from small businesses that need a little help here or there with small business HR, with just corporate compliance, up to large companies that we do everything nationwide, that we're the legal department. We go to the board meetings, we do every agreement with suppliers, we help them build their factory, we do all their HR issues. And so that's kind of the relationship we like to have where we do that. We do some of that, like most lawyers do almost everything hourly. We're actually probably the exception, that we do almost half of our work on a not hourly basis. And that's what we call retainer-based work. And so once we get to know folks or businesses, when they get there, we'll figure out kind of what that scope of work is and do that for a fixed budget. So you have a budget for your legal department, your legal spend, and here's what we're going to do under that. We're handling your corporate. If an employment issue comes up, you have a separation agreement, you have an issue with a vendor, whatever it might be, you need to file a trademark for your business. You have somebody send you a nasty letter about the trademark you're using for your business, whatever it might be, and do that sort of scope and help people move along as they grow. And we're proud to say, I think that since we started the firm in 2013, we left a large national firm and brought a bunch of clients over that were interested in sort of that model, that the only clients that have stopped doing that with us are ones who have sold their business and retired and sold it to some big company. But otherwise, I think maybe we may have one exception of somebody that wound down their business, but pretty much everybody else, we're still doing that work and working that way. And I think it's a testament to that being more of a win-win relationship, right? If I'm more efficient in solving your problem and keeping you out of trouble, that's better for me, right? Versus spending a lot of time. By the same token, for the owner, we always joke that preventive maintenance is very cost effective in our business. Cleanup is really, really expensive. So we're going to do some things here that talk about places where I see folks sort of kind of getting in a little bit of trouble that way. The ones we had a bunch of changes come through, and they're getting old now. Is kind of my joke, is that the first raft of all these new employment laws in Virginia came about actually back in 2020 and 2021. We had a lot of change in new statutes and things that were employee protections. Some of those got a lot of publicity, some of them didn't. But what's happening is it takes some time for that to work its way, and the plaintiff's lawyers to figure out that there's claims here, there's things they can do, or for people to realize, oh, wait, I can go talk to somebody about this issue. And so we're going to touch on, we talked about a bunch of those last year. This year, we're going to touch on the two that I'm kind of seeing continue to generate the most actual claims and disputes and lawsuits and things that we get stuck dealing with. The first one is this, what they call worker misclassification law. And so all of you know, in small businesses, it's very frequent sometimes we have employees, but also tend to use sometimes 1099 contractors, not always in a position to bring somebody on and provide benefits. And so, oh, we'll make them a 1099. Do they want to work that way for you, right? You got somebody doing some IT work on the side. And they say, well, I'll just hire me as a 1099. And a lot of that went on. And we've always had this IRS test that was kind of muddy. It's this, 20-factor test. They kind of compressed it. It's always doing things about control and opportunity for profit, and do they do it for other people, and all, no factors controlling. And it was always kind of gray. But certainly over the last 15 years, the kind of gig economy and people doing that type of work on the side and people using folks that way has grown quite a bit. This statute in Virginia is one of the most sort of protective, or maybe overprotective in my view, but it basically says there's a presumption that anybody that provides a service to your business for payment is an employee, not an independent contractor. And you as the company have the burden under this Virginia statute to prove that they meet the test to be an independent contractor. They had a profit motive. They hold it out for others. Is it part of your core business? Is it something you have other employees doing? They look at all this stuff. And so that's a bit challenging. And the biggest thing is it gives a private cause of action for those folks to sue you, and provides for attorney's fees and all kinds of fun things. And so, the comment always is, when does this come up, right? Well, when the relationship doesn't work out, right? There's not a lot of risk if you both are best friends and you like each other, but as soon as there's an issue, you've now got this risk. And if you start using those sort of folks on a broader, sort of scope, when the DOL is doing audits, so one of the things that will happen is, right, you're paying into workers' comp, for example. You're paying in the unemployment system, for example. You have to report your payroll. When you get audits now, they're sending you a questionnaire and they're asking you about people that made more than $600 on a 1099. If you've got a 1099 with a person's name on it, they're going to ask about that because they want to collect tax, right? If that person ought to be an employee. And we're seeing those misclassification issues come up in that context for a lot of folks. And it's been an issue that's really expensive to fix because you paid them, right? You're responsible for the employer side of FICA. You can't go back and get it from them. right? You didn't do the other Social Security withholdings, all these things that come out of that, and all the other benefit costs, the value of the benefits they would have got if they're an employee, particularly if they were working more than 25 hours, right? If they were working enough that if they'd been an employee, they would have gotten benefits. They have a right to the value of that. And so it can be a really kind of problematic. And so you want to be really, really careful about that. And if you're using them, let's have an agreement, right? Are they an LLC? Can you make them form an LLC? So the IT guy that does that for 10 people, right? If he's doing that as a business, there's not a huge risk in that. If I bring in someone part-time to help me do something that I also have employees doing and I pay them that way, much, much riskier. And so we're telling folks, if you're using anybody in that status now in Virginia and you don't have an agreement that lays out there an independent contractor that sets up the criteria to meet as much of that test as possible, right? But if you control their schedule, if they report to your manager, if they're out, all those things are things that are going to push that view to look at them like an employee, and they can be really expensive claims. The plaintiff's attorneys love them because even if they only recover $5,000, they get their attorney's fees, which might be more than $5,000. And so they're attractive claims. So we want to be careful about that.
Are you saying with that though, like if someone's subcontracting, I'm gonna use my wife as an example.
Yep.
She's a wedding photographer and she will second shoot for someone and they will subcontract her for that.
Yep.
Or she'll hire a second. As long as the other person is a business and has that and has.
Yeah. So generally speaking, if you hold yourself out to the public, you have some risk of profit and loss, right? You're doing all those things. You have your own equipment, right? So she kind of looks like an independent contractor. She's doing that for a bunch of other people. Now, if they said, we want you to just come do that just for us, you have to use our camera. We're going to set your schedule. We're going to pay you by the hour. We're going to give you, shit. What? All of a sudden, you say, wait a minute, that doesn't look quite like a business owner now anymore, does it? And so that's kind of that thing that you've got to look at and say, what do they kind of look and smell like? If somebody walked in here, would they think they're an employee? And we have ones where people are holding people out, getting paid by 10 as an employee. They got business cards. They go, then you start saying, well, this is starting to look kind of problematic. So that's a challenging one if you're out there to do something with. So be aware of that. And the government can fine you as well. And this is if you start to have multiple ones, can be a big deal. I put this one in here because we have a lot of folks in the chamber that are in the construction industry. When they passed this, they added a section. And so contractors, if they're misusing and misclassifying people, that can actually be a basis for them to get their license suspended for not classifying people properly as a contractor. And of course, in the construction industry, everybody that shows up at your house to work on something is a contractor for somebody, right? And they're really cracking down on the individuals doing that and kind of putting everybody into that bucket. So you got to be pretty careful. The other one that I'm seeing more claims of is, Virginia, it used to be that your personnel file for your employees, that was company property. You didn't have to share it if you wanted to have them come in the office and look at it. And the old rule and is you want to look at your file, come on in the HR person's office, sit down, we'll let you look at it. But we're not letting you make a copy, and we're not giving you a copy if you've left, right? Because why on earth would I want to do that? You're obviously talking to some lawyer trying to sue me. I don't want to give you anything. Well, you actually have to now in Virginia. We have a statute there that provides damages, and it's not everything. And so if you've got an investigation, talks about other people, there's limits on what you have to provide. But just saying, I'm not giving you anything, if you get a written request, whether it's from a lawyer or from a former employee, you better take it seriously, at least turn over the stuff you're required to, which is, you can kind of see on the slide, the stuff that's out there. It's not real clear between this list of 4 things and the stuff that's in a normal personnel file, how much of the other you can pull. And so if you have one that there's anything in there you'd have concern about, talk to somebody and we can kind of give you a little advice about kind of what to do out there. But you have to respond within 30 days. You don't have to keep any particular records under the Virginia statute. Whatever you have, if they make a proper request, you're probably going to have to turn over. And so you got to think about that. There are some exceptions for safety, right? If there's a workplace violence threat or somebody's unstable, there's an exception for that. And there's an exception for HR folks that have access, what they can and can't do.
Back to that list for me?
Yep, absolutely.
Yeah.
Yep. It's anything that should, but what it says is you have to provide any documents showing these things. So is that any document that has date of employment or salary? Or is it the main ones that show that, right? And so that's where it gets a little bit gray about, all right, well, lots of things might show a date of hire. Does that mean any document with date of hire? Does that mean, and so you get into a little bit of gray of kind of what can be there, but that's
also, so wages or salary, they might say there's a base salary, but not include bonuses, for example.
Right. But any type of wages or salary, stuff that shows their bonus, payroll records, they're entitled to copies of all of that stuff if you've got it. Show them all your benefit withholdings, anything that shows how they got paid, how you calculated, what bonuses they got, all that stuff. If they send you a request, you got to turn it over.
Okay.
Does that have a time limit?
It's as long as you kept it. So it's whatever you kept. Now, the state statute doesn't require you to keep anything or anything for a particular amount of time. You do have some obligations under federal law for payroll records to keep them a certain amount of time. So that's the only thing that would kind of kick in there. But you wouldn't violate the state statute if you said, well, we only kept them a year and you're supposed to have them 3 years. They don't care. It's just what you've got at the time, which is kind of an interesting. So Joe, so think about that. I still see lots of handbooks that people ask us to look at that have language in there about that doesn't match the statute. Then you get into the thing you have of, well, what should I be keeping and for how long? And everybody gets really confused. You start going on the internet searching that, you will confuse yourself to no end because there's so many different rules and statutes and all that sort of thing. But if you don't have a good retention policy and you're starting to grow where you've got 10, 15, 25 employees, let us know and we can get you kind of a list of what you need to be keeping under federal law for benefits, pay, OSHA records, all that kind of fun stuff. There are rules on almost all of that. The last piece on this that we're seeing tie into all of these different claims is you sometimes hear this Bowman word or whatever, this idea of employment at will, right? Virginia's always said we're a really strong employment at will state. And what does that mean? And we still are and we aren't. I tell folks, yep, it means you can fire somebody for a dumb reason, for no reason. You don't have to tell them the reason, but it can't be an unlawful reason, right? It can't be one that violates any federal or state statute. And so, that's been curtailed quite a bit. And we balance that with now we have all these protected claims in Virginia that even if you're not a big employer, right? Most, Title VII kicks in at 15 employees. Some of the ADA, some of these other statutes kick in at 20 employees. Even if you're below that, there's a thing called the Virginia Human Rights Act that provides all the same anti-discrimination, all the same reasonable accommodation for disability protections and all those things. Some of those kick in at 6 employees and they vary a little bit depending on your size. But if you're in that 6 to 15 employee range, a lot of times people thought they didn't have to worry about any of that stuff because they weren't big enough yet for the federal law. But now the state law is giving people the same right and they can bring that claim in state court. And if they come to you and say they think you're doing something wrong, we now have this whistleblower statute that is incredibly broad. I think you're doing something wrong, employer, right? I don't think you're complying with that state law. I think you're hiring. I think you're making me do something unsafe. Anything that would arguably encompass, right, a violation of some rule or statute is protected under that statute. And it gives anti-retaliation protections that include things up to reinstatement, but it also lets them sue you. And so almost every claim we're getting now from the plaintiff's lawyers that involve a disgruntled employee or an employee that's left, they're tacking on a whistleblower thing, right? Whatever I complained about, I came to you and said I was being harassed out in the shop or by some manager, or somebody did something inappropriate or whatever it is, and you didn't handle it right. And I complained to you about it, and I don't like what you did, or you didn't do what I think you needed to do. And so now I think you're treating me differently, right? Anything bad that happens to me after that, you did that to retaliate against me because I was a whistleblower. I asserted my rights under one of these statutes. And so they're really easy claims to tack onto everything. And they include attorney's fees, and they're a state law claim. They're really hard to get thrown out on the front end. And so the plaintiff's lawyers just see them as having great settlement value. And so almost everyone we're getting a letter now about anything of somebody that's been let go is they're going to find something they complained about that they didn't. Well, I didn't think you were assigning overtime fairly, and that was discriminatory. I think you weren't complying with OSHA safety rule out in this area, or you did whatever, anything somebody can come up with, you can tie back into this statute because it's so broad. And we're seeing that as just a way to kind of try and create value because it has all these other things you can ask for. Attorney's fees, reinstatement, lost future wages, right? I think that's part of your decision to let me go was that I complained about something. And so I want my front pay till I find a comparable job. And you can ask for that under that statute. And you get a jury if there's a question of fact about any of it. And you don't get jury of business owners. And so it's become a really big issue that I think you got to be, if you get a complaint about somebody saying they don't think you're doing something right, take it seriously. Even as a small business, there's not a lot of room there to move around and not have a risk of sort of getting in trouble. The next one we're going to talk about is the changes in what are called non-competes or restrictive covenants. I still see lots of small employers, particularly with folks that have a sales role or have a lot of client contact, wanting to have, right, some protections from that person going to another company. You help them give them business, you give them your customers, and then they go down the street and go somewhere else. Virginia used to kind of allow that, and the question was whether the court would enforce it or find it was too broad. Now we have a bunch of group of people that can't have one at all. And so they talk about it as a low-wage employee can't have a non-compete. What do you think a low-wage employee in Virginia is? for the way they defined it under the statute is anybody making less than a little over $76,000. Now, in our part of the world, we consider that a pretty nice salary. But under that statute, you can have a $75,000 salary and it's unlawful to have a restrictive covenant with that employee that prohibits them from going to a competitor when they leave. And even making them sign the agreement is a violation that they can sue you and seek damages over that it limited their job opportunity, whatever it might be. And you can get fined by the state for entering into one with someone where you shouldn't or trying to enforce it. And so you think, my gosh, you got to be kidding me. It's important to understand what the statute does and what it doesn't do. So it's talking about a covenant that restricts following employment who they can accept employment with. That doesn't mean you can't have some restrictions. And so if you draft them narrowly, and we see people kind of doing the thing you can't do, right? Which is that you can't work within 50 miles for anybody else that, right, is in the pest control business. Have a nice day. Well, you can't do that. It's not going to fly. But you can say, you won't solicit business from any of my customers that you serviced for a year. Yeah, you want to go work and have at it. But don't go to my customers and ask them to switch for a year. You're allowed to have that kind of thing if it's narrowly drafted. And there's language in the statute that says, as long as it's reasonable, isn't written so broadly that they couldn't go work there, right? You can't turn it into a non-compete by making it cover, anybody they've ever, talked to, seen, and whatever, right? You can't make it prohibitively, but you can do a narrow one, and you can do it for customers and for employees, right? That you don't want them to take. So it's a pretty broad statute as far as who's out of it and who's in. Well, the other interesting thing about it is it also prevents that type of restriction with independent contractors unless they're paid. And it's gone up a little bit from that 20, I think it's maybe close to 25 now. But if you have a fairly low wage 1099 sort of person, you can't have a restriction on what they do outside of that in that independent contractor agreement either. And so includes trainees. We've had this issue come up with folks in the CRC with some big companies, the engineering students at Tech, they're going to come intern somewhere. Well, they want some protections there, and you got to be careful about that because those people are covered. People that are purely commission based, if you have a salesperson that only gets paid or most of their income comes from commissions, there's actually an exception for those folks. You got to make sure you define how you pay them correctly to meet it. But if you do it correctly, you can still, for a pure salesperson in a small business, have that type of restriction if they're commission paid. And so you want to kind of be careful about that. General confidentiality and don't steal my IP and don't take my customer list, all that stuff is still fair game. The other thing they added this year, and it's gotten almost no press, is anybody that's overtime eligible, even if they make a lot of money, no matter what they do, you can't have a non-compete under the Virginia statute with anybody that's a non-exempt employee now. Doesn't matter what they make, doesn't matter what they do. If they earn overtime, you cannot have one of these restrictive covenants with them. And so a lot of people haven't seen that. The other one that's just a quickie is employees talking about what they make with other employees. That's actually protected now under this paid transparency law in Virginia. So you can't fire or threaten somebody. Don't tell Steve what you're making because I know you're making more and they'll be mad. You're actually not allowed to do that anymore. And we saw that out there. There's some exceptions. If you know what somebody's paid because you're in HR, you can't go use that for other purposes, right? There's some things like that. The other one that we're not going to really talk about, but I put it in here just to get everybody's attention. We spent some time talking about it last year, and that's this idea of who's exempt and who's not exempt. I put some more detail in the slides here, and while we're not going to go into it in a ton of detail, I want you to have a little bit. This continues to be, for smaller employers in particular, probably maybe the most common mistake of who can be salaried and not get overtime. A lot of people think, well, I pay them a salary, right? And I looked it up in the thing, and it's like above 38,000, it's above the number, I'm good, right? I'm paying them a salary of $50,000. I don't have to pay them overtime, right? That's only half the test. That's the salary side of the test. There's also what they call a duty side of the test, meaning they have to be doing a job that qualifies to be exempt also. And so that can be a manager, right? If they're supervising 2 or more people, that's going to get them there. They can be a professional, right? If they're an engineer or a doctor or, right, something that's got some advanced degree. If they're if they're handling a certain part of your business, and you start to walk through this test of like, all right, well, what am I doing, right? And the top of that is, right, am I the manager, right? Am I the president of the company? Am I heading some big part? Well, maybe I'm in pretty good shape, all right? The place we get into trouble are these middle ones. Primary duty, office, or non-manual work related to management or general business operation. And so that's like, if I'm the VP of marketing, I'm coming up with a marketing plan for the company, right? I'm not out providing the service we provide to the customer. I'm helping come up with a plan to do it, right? I'm the CFO, I'm the accountant, I'm some sort of administrative manager. But if they're involved in delivering whatever that service you do to your customer, they're not going to fit under that part of the test. And even if they are working on the business stuff, right? I've got somebody in accounting. I think, okay, well, they're not doing the client service. I'm good. Then you've got to meet this part down the middle of, do they have enough judgment and discretion in what they do to be exempt? If they really don't have any authority other than they're buying office supplies and, things that anything meaningful is getting approved by somebody else, you have a problem. So you can hire somebody that has a CPA degree, right? But if they're doing ledger bookkeeping and balancing your book and everything that's on budget or all the big stuff is getting approved by somebody else, they're probably not exempt. They have the skill set to be exempt, but they don't have judgment and discretion, right? They're not doing forecasting. They don't have control over who to pay and not pay, right? They're basically an accounting technical person. And those people aren't exempt, even if they're paid 50, 70, no matter what you pay them, really. And so you want to be mindful of who's in that bucket. And if you're not sure, talk to somebody. Everybody always thinks that anybody doing computer stuff, because there's a section that says computer professional. I think, great, that's my IT guy, right? And that test, if you look at it, is really more people that are writing code and designing equipment and network, the guy that's designing a network for a company and all that. The person who installs the stuff for your user and make sure your printer works and you can connect to the network, that person is not in this definition. So be careful about lumping some IT folks in there without thinking about it a little bit. The other sort people get in trouble with is they say, well, the salary's above it, I'm good. There's limits on what you can deduct and still be considered to meet the salary part of the test. So in other words, I can pay somebody a salary of $70,000. I think I'm well above the limit. I'm great. But if I make deductions that aren't allowed, then I lose the benefit of the exemption. And what happens when that happens is they're entitled to overtime. And they can come back when they leave and ask for 3 years of it, which is really expensive. And of course, you thought they were exempt, so you didn't have them fill out a timesheet. And so the DOL's view is, well, if you didn't keep the timesheet and you were supposed to, because you didn't pay them properly, then what's the best evidence of how much overtime they worked? Well, we'll just ask them. And they'll give them a little questionnaire on the average week. How much you take work home? Do you respond to emails from home? Right? Do you do this, that, the other? And everybody will, oh, yeah, every week, 5, 6, 7, 10 hours. And all of a sudden you think, oh my gosh, it doesn't sound like a lot. But if you say 5 hours a week over 3 years at somebody's overtime rate, if they make a $70,000 salary, that's a really big number. Add some interest to it, add some attorney's fees. Now we got something that's fun for lawyers, not fun for you. And so I put these in here. I'm not going to spend a lot of time on them, but the idea is that if the salary, they're ready, willing, and able to work, they're supposed to get their full salary. Now you can charge it against their PTO or their sick leave or these different things. But absent that, anytime you're not paying them the full salary for the week, it's got to fit under one of these, what they call docking exceptions. They've used up all their leave and they're absent a full day or longer. You think, okay, that's fine. So I've used up all my PTO. I come in and work a couple hours. I don't feel got to go home. If you dock me those 6 hours, guess what? You just violated and blew my exempt status out of the water. And if I do that repeatedly and I don't fix it when someone brings my attention, they can claim 3 years of overtime. And so you think things like that. And so you want to be careful about that. Penalties, they have to be really big deal safety violations. It can't be little piddly stuff. FMLA, if you're big enough to do that, any FMLA is going to be there. First and last week, you don't have to pay them the whole week. That kind of makes sense. And so you look at all these things that happen out there. I go to my parent-teacher conference, but I don't have leave available for it. You still got to pay them. Now, you can discipline them for being absent half the day without leave and without permission, but you got to pay them. And that's what always frustrates people a little bit. And so I threw a few examples in there, but that's one I always tell folks, be careful about that. The old rule used to be really draconian, that you'd lose it for like everybody in that job and you'd get these big class action. It was really, now improper ones, if they're individual, as long as you reimburse them, you can kind of fix it. If you don't do that, you got some problems. You have to have a policy that says, hey, come to me and I'll fix it if I do it wrong, in order to take advantage of sort of the safe harbor and not risk losing the exemption. And so you want to see if you have that out there and figure out, well, how am I going to communicate that out to folks? And so that's one that, that rule's been that way for years, but we see those claims constantly still where, somebody's docking somebody, they're frustrated with somebody's doing whatever, all those sort of things that happen in the pull and push, deducting from leave, making them track their hours. It used to be under the old rule. You didn't want somebody who was exempt to track their time. because that made him look non-exempt, made him look hourly. That went away in 2006, but you still read articles and things that tell people that, which is completely not true. You can set their schedule, all those fun things. None of that stuff kind of affects it. The other is people think they can't pay some voluntary extra pay for overtime. And actually, under the current rules, you can. So if you want to voluntarily pay someone who's working a bunch a little bit extra or pay overtime voluntarily, that does not screw up their exempt status. And we have folks who do that. I've got some engineering and service firms who say, well, gosh, if somebody's working, right, if I got somebody over here working 60 hours because they're on a big project, well, shouldn't they be getting something for that? And I'm over here barely working 38. And so you're allowed to do that now. And you can set that criteria based on anything you want. It could be a straight overtime. It could be above 50. It could be a flat amount. It could be kind of whatever you want to do. So we're going to move into what are the things that I see kind of my top 10 list of sort of problems. And then we're going to talk about a few corporate kind of sort of compliance issues, right? Not actually having a harassment and EEO policy. It used to be a lot of small employers think, well, I'm not big enough to be covered by these federal statutes. I don't need one. Well, you're under the state statute. And if you don't have one, that's going to be a problem because part of the test is, right, if you don't tell the employee you have a policy and that you'll investigate and you'll take action and all that kind of fun stuff, they don't have to tell you that they're being harassed before they sue you. If you have a policy and a complaint procedure and you communicate it to people, then there's two types of harassment. If I fire you because you're an African American or because I don't like your religion, I'm still on the hook, right? You don't have to come and make a complaint about that. But most of what we see is what hostile work environment. My coworkers harassing me, they're discriminating against me. Those kind of complaints, if you have the policy and you have the complaint procedure and they don't come tell you about it and give you an opportunity to fix it, that can be a bar to their claim. And that's huge. That's the best way to get something dismissed, right? We had the policy, the police, you never told us about it. Have a nice day. If you don't have the policy, guess what? They don't have to do it. And so I still make sure you have something there. When you hit that 50 employee mark, FMLA, you got to have a written policy. You got to tell people about it when they ask for any leave that's medical related. If you're hitting that standpoint, make sure you're there. Handbooks and personnel manuals, particularly for small businesses and privately held businesses, are kind of all over the place. The most frequent one I see when new people come is they found one on the internet or from their former employer, or they got one somewhere and they kind of cleaned it up and look at what we have. And some of those are pretty good and some are not good. Some have the disclaimer and some don't. And there's always this dance of you don't want to make the handbook a contract because you want to have the flexibility, right, from a management standpoint to make exceptions, to change the rules and do all that. And if you're not careful, I see one sometimes where they make people sign and agree and then the company signs and they got this whole thing. Like, well, that starts to look a little bit like a contract, doesn't it? Now the employee can say you breached our deal when you didn't do something or change something. And so we want to make sure when we're looking at this stuff that we have one that has a disclaimer that says, hey, these are rules and right, we expect you to follow them and you're an employee at will. So if you don't follow them, we can take whatever action we deem appropriate. But it isn't a contract. We got the ability to change it. We want to make sure you haven't lost that part of it when you pulled some policies. The other thing I see is ones that are just complete overkill. I had somebody send me one last week. They have 8 employees and they sent me a 78-page handbook. Now, do we need 10 pages of rules for each employee? Seems a little bit much for me. And the problem with that is what? Nobody knows what's in it. You're probably not following all of it. You're not going to be able to keep it up to date. And what are you doing with that, right? And my view is let's get the key important things, but we're not trying to have a rule for everything. And if you're a big corporate company with an HR and you're trying to get consistency across all these locations and things, right? Maybe there's a reason to get down to that level. But if you've got that as a small business, my thing is you've kind of lost track of what you're trying to do somewhere along the way. The other is employment application forms. This is kind of an interesting one that's changing, and what we see causing problems has changed a bunch. It used to be the biggest problem I saw is people have an old form, right? They got a box of them at Staples, right? And they pull them off and give them to people and have them fill them out, or they got one online and they printed some of them and they had things in there you're not allowed to ask about anymore, right? They didn't have the right language to ask about immigration status. And you're limited in what you can say about that. And so if it's an older form, it probably doesn't phrase it the right way, and that can be a violation because you're only allowed to ask certain things about immigration status. It might ask things that would indicate the employee's age, right? What year did you graduate from high school? All those kinds of things that are proxies for age. Well, you're not allowed to ask about age. It might ask questions about physical duties on a job or about certain things. We're not allowed to ask about that stuff in the application form. And so we see some of these old forms have been around forever. They look real nice. but they ask stuff you're not allowed to ask. So if you got an old form, look at it, ask somebody, maybe find a new one and sort of look at that.
So
that kind of stuff.
is there a proper way to ask if someone is a US citizen?
There is. And so, but it's limited to whether they can lawfully work in the US. You can't ask if they're a US citizen, for example, and you can't ask what their immigration category or status is. And so generally speaking, there's kind of a boilerplate that asks whether they're lawfully able to work in the US. That may be a citizen, that may be a visa, they may be a spouse with an EAD work authorization. They could be an asylum person from Haiti that's got an EAD that allows them to work while their case is pending. And so you're not allowed to ask what that is, but you're allowed to ask whether they can lawfully work in the US or tell them that they're going to have to provide proof of that as part of the process. A lot of people, some folks that have a high volume will keep that. We see a lot of folks now not doing it, just using E-Verify or using the actual I-9 and say, we're going to find out then, right, if they can lawfully work here or not. So I don't really need to mess with that on the front end of my process. Bigger companies that have a lot of volume will ask. Folks that have a lot of folks in engineering and certain jobs where there are folks that have H-1B that may need a sponsorship from an employer. And there are things you can tell someone, hey, we don't provide sponsorship, right? In other words, if you got an H-1B from one employer or you're an engineer, you want to move over to me, I don't have to hire you and agree to pay and sponsor you. That's up to me if I want to do that. And so you can get into some more subtle stuff there that you want to be a little bit careful about. The other one that has really blown up from a claim standpoint, and we've had 2 lawsuits over this in the last 3 years, one with a bank, one with a hospitality company, is do you have people apply online now? And it's becoming more and more common. A lot of folks require it, right? Either through some portal or make them submit everything electronically to you because you don't want all the paper. So there's a whole bunch of rules about making your hiring process accessible to people that have a disability. Maybe they've got a vision impairment, whatever it might be. And so you need to have, if you require people to use an online application or portal to apply, you have to tell them and have some mechanism that if they need help with accessibility because of any limitation they have, that there's some way for them to get it. They can figure out who to call. They can apply a different way. They can do something. And if you don't have that, that's a violation. Now you think, how many seriously visually impaired people are actually likely to apply for a job with you? Probably not that many. There's all kinds of litigation about it. Why? Well, it's a really easy violation to prove. And so they have all these people that are called testers. Our bank case, it was a guy in Northern Virginia who's legally blind, and he was going everywhere, all these community bank sites, and trying to apply for a car loan. Now, is a guy from Northern Virginia really trying to get a car loan from a small bank in Southwest Virginia? Probably not. They're getting paid by lawyers to go out and they'll go to a hotel website and see if it's accessible to make a reservation. They'll go try and apply for jobs. And these people sit all day long trying to look up places that have job postings, and then they go to the link, and if it doesn't have an accessibility thing, they do something, and then they kick it over to these lawyers. And these people, there's a firm, that's in Virginia's probably fired hundreds of these things. And they're just doing it to try and settle, right? You didn't meet the statute, you didn't provide accessibility option, bad mark on you, give us a couple $1,000, we'll go away. And these people do this. So there's a lot of these tester sort of cases out there. Some courts are allowing some of that, some aren't, but it's an expensive problem to have and an easy one to fix. So if you do that, take a look at that. I think online applications are great and more efficient, but make sure you've got that in your process, or you're using a provider that includes it. Yes, sir.
Just as a caveat to that also applies to your business website.
Absolutely. And so those same ADA rules, and it's an interesting, there's a dispute between courts in different places of whether, if you are a brick and mortar store that also has a website presence that's more marketing, whether the rule applies. And some courts have said it applies to everybody. Others have said if you sell a product online, right, or if you're only online, it clearly does. And this whole idea is there's public accommodation ADA. And in the old days, that was, is there a ramp out front, right? I need to be able to have an accessible route to get into your business because I've got a right to come and shop. If I'm at a hotel, I should have the same benefit of the pool. So you got to lift all the things that come, that if you're a place that's open to the public for business, whether it's a bank branch, office, whatever it is. And then, yeah, so now that you're selling online, you have to have those same accessibility options for customers. And that includes things not like just, hey, call, but do the pictures on your website, if somebody rolls over them, say what it is so they can access. Is there text to speech stuff? Is it compatible? And there's standards out there that tell you, that will actually rate, and tools, you can go rate your website and see if it does good or does bad. There's no specific standard, but if your site is real bad, you're at risk of getting one of these nasty letters. It's the same thing. They just have people all day long going to websites for businesses and just testing it. They run the software on the website and say, oh, that's a bad one. That one failed. Let's send them a nasty letter and ask for some money. And it's a cottage industry on that ADA accessibility issue. And Congress has not fixed it. There's been efforts to try and draft some more specific regs to tell people what they have to do, tell you which businesses apply. And right now we got nothing. And we're probably not going to get anything for the next few years. So it's a big area. And it's a difficult one for small businesses because what do you do with that, right? You're not big enough to go fight with these people. So you end up having to do something there. When people leave, what do you do? And companies are kind of split. Obviously, if somebody, you catch them with their hand in the till, you can fire them. I'm not really worried about a severance agreement or a claim in that instance. I feel pretty good that no matter what else they did, I had just cause to fire them. But in performance issues and other places, I tell folks, if you're not thinking about offering some transition help, you probably should be. And if you think about it, right, how long did you put up with their poor performance and continue to pay them while they were there? Maybe you ought to do it for another 2 weeks or a month. Most people, if they're mad about getting fired or don't think it's fair, they might turn down a week or 10 days of pay or something like that. But once you get out past a couple of weeks, 70+% of the people take the money and sign the release. And then you're not going to have a claim from that person. I kind of like that insurance. It's pretty cheap. And you have to have an agreement that says they're releasing claims. There's special language if people are 40 and older. I used to think that was a good measure for when people were old. My view on it has changed a little bit in more recent years, particularly in the last decade, since I've been above that number. But there is a language that for somebody to release an age discrimination claim, you have to give them 21 days to think about the offer and go meet with the lawyer because they're old and slow. It takes some time. They're going to be able to understand it. And then they actually get a week to revoke it and decide, yeah, I shouldn't have signed that. I really don't want your money. I want to sue you. And that's under what's called the Older Worker Benefit Protection Act, that the older folks, when they do a big layoff, they take everybody release. If you want the money, sign here. One-time offer, right? You want 2 weeks of pay or not? Sign here. And it was meant to stop that. If you don't follow that, you can still release every other claim except age discrimination. So there are times sometimes where we want to do something and don't want to take that time. And we'll say, you know what? I'm not worried about an age claim from this person. They're over 40, but they're the youngest person in that job or that role, right? It's not something I care about. If you don't care about it, you don't have to do it, but you can't release an age claim if you don't do it. So think about that. Confidentiality and non-disparagement provisions. This is an interesting one because my view, and for a long time, I'd make them as tight as possible. I don't want you talking about anything, right? I don't want you to say anything bad about the company. I don't want you to post anything about me on Facebook. I don't want you to tell anybody that you got any money from me, right? I want this thing as locked down as possible. I still would like to do that, but I have a problem now that it's illegal. And so I hate telling people to do things that are illegal because I'm really not supposed to do that. I don't want to do, obviously, I don't want anybody to get in trouble. And so what's happened is the federal government, and this may get rolled back a little bit with the current administration, but the law currently, the Department of Labor's view is that if you prohibit an employee from talking about the things that led them to leave and enter into a severance with you, that is restricting their rights to talk to their coworkers about working conditions and potentially form a union and all this stuff, that's protected speech. And you're limited in what you can tell. You can make the financial term confidential, right? Don't tell them that I paid you $10,000, but you can't make it, if you tell anybody I paid you anything, if you talk about why you left or the dispute we had or anything, you got to give me my money back. That's illegal. And they keep your money and they don't have to follow the release. And so that's been the rule. Gosh, I'm trying to think how many years ago they switched that, probably in the last 5 to 6 years. And so you have to be a little bit more careful about that, about non-disparagement clauses, right? Because they're allowed to talk about you. Now you can say, don't defame me. That's okay. Well, they can't really do that anyway, but these don't say anything negative about it. Don't post anything on social media. And so it's interesting. That rule applies to anybody that is what's called bargaining unit eligible. So an hourly employee, somebody working in a factory, somebody gets overtime, some kind of worker bee sort of person. Does not apply to professionals and managerial employees. So if you fire somebody who's a VP of ops, you can require all that stuff from them, but you can't require it from your hourly person that works in your store, even if you have good reason to. So you want to be careful about that. Credit checks and background checks on applicants, I think they're a great idea. They're pretty cheap now. There's all kinds of services that do them. They do a pretty good job. Virginia, you can't use arrest records, that sort of thing. The thing that I see smaller employers getting into trouble with, particularly if they use these online services, is if something on that credit report, now if I just look up your criminal record and nothing else and see that you've got a conviction for murder last week that's on appeal, I'm pretty safe to just use that and not tell you not hired. Not super worried about that. But what do most of us do? We use an online service, we pay them $40, we have them run a credit report for us. And then we say, oh, this doesn't look good. I think maybe we'll move on to the next candidate. If you do that and do nothing else, you violated the Fair Credit Reporting Act. it requires you to tell the employee in a letter, give them a notice about their rights under that statute, tell them, hey, something in your credit report came up that's a factor in our decision not to move forward with you. And you have to tell them what service you used. And the idea is, well, what if it's wrong? That's not, I'm not the Jim Cowan that all that bad stuff relates to. That's some other dude. Or it's wrong and I want to challenge it. And they have a right to do that. Then you have to give them a notice so that they can do that and give them a certain amount of time. And then you got to tell them if they don't do that, what you're doing. So there's a series of notices that you have to give the employee. And a lot of these services will tell you that, but a lot of the cheaper ones, they kind of put that on you. Some of the bigger companies, they'll actually do that for you and handle doing the letters and the notices to make sure they're right. It's not hard to do. If you do those, you don't have them, let me know. We can get you a set of the forms. They're not, they post them online. I mean, here's the notice, here's what the letter has to say. It's not doing it to get you into some trouble. So you want to be thoughtful about that. So document retention for small companies is often an issue. I listed a couple ones on here that have specific rules. There's lots of others. Benefit plan docs have a longer time period. There's all kinds of things you have to do. And that's one that if you get audited can be a problem. Or if you get sued and somebody thinks that's relevant to it and they say, oh, well, you didn't keep something you're supposed to, it must have been bad, that kind of stuff. And so you want to be thoughtful about that. If you've never kind of looked at that, let somebody know, reach out. We've got a schedule we share with folks. We kind of have one that's a little simpler and one, if you really want to know everything, oh my God, it's like an Excel spreadsheet. And here's all the different rules on different things, depending on kind of what you do in your business, OSHA injury records, all that kind of fun stuff. So make sure you're being thoughtful about that. That can be a risk factor. We talked a little bit about the disabled applicants and employees. I'm not going to touch on that part. I think the only thing that I would sort of add with this part is kind of where you talk about it in the process. The ADA is sort of a weird statute, but if you understand the logic of it, it makes sense. It's the only statute that actually makes it a violation to ask an unlawful question during an interview. And the case study that I use is a case from Texas, and it's getting old now. It's probably 10 or 15 years old. There's a guy who was a salesperson. He'd been in sales going into businesses, and he went to work for those places that comes in and says, fire your coffee service, hire us, our coffee's better, we'll come more often, we'll give you fancy espresso machines, whatever. Clearly qualified, had been in the business of doing, food and service products to businesses, was a finalist, they interviewed him, all this fun stuff. And he had a surgery, and in that surgery, they had nicked a nerve or something, caused some nerve damage on one side of his face. They had a little bit of paralysis, almost like have you seen some of Bell's palsy, where one side of the face sort of sags in the lip, and you can have some hearing loss connected to that. And so he basically had those same symptoms. And in the interview, somebody asked him what had happened. He said, well, I've been out for surgery. I said, oh my gosh, what happened? Was that illegal? Probably not a great question for an interview, because it kind of leads you down and maybe talking about a disability, which I don't like. But the court said, well, that was obvious. That's not illegal. Like if someone comes in, their legs in a cast, you can say, oh my gosh, what happened? Right? That's okay. But then during the interview, somebody asked him, well, since you've been back to work, have you been comfortable still being out in front of people? How have people reacted to your disability? Oh shit, now we got a problem, right? And the court said that was unlawful because it was asking about how his disability impacted his ability to do his job. And that's the same as asking someone in an interview, this job requires lifting, can you meet that? You got to go lift these sacks out of the truck, you got to do whatever it is. You're not allowed to ask that during the interview phase. And so they said that was an unlawful question. What's interesting about the case is they won the part on the failure to hire. In other words, they were able to show he wasn't the most qualified candidate, and the person they hired actually was more experienced. And so they won that part of the case, but they awarded the guy $55,000 because they asked him an unlawful question during the interview that he wasn't the best candidate for. And the hook of that was attorney's fees, whatever. So it's kind of a crazy statute, but the logic sort of makes sense. The idea is I've got these two candidates coming in for a job, right? They're both obviously probably minimally qualified, or I wouldn't have brought them in. They wouldn't have made the interview list, right? And so they want me to decide between the two of them, who's my best candidate. And then after I've made what's called a conditional offer of employment, I'm allowed to inquire about whether they have a physical restriction or something that would prevent them from doing the job. And that can be a whole broad range. It could be a job that has some physical components to it, lifting stuff or whatever it might be in a plant or even in an office setting. It could be operating a vehicle, could be all kinds of things. Comes up sometimes if somebody has particular sensitivity to chemical, right? Something they can't work around, certain materials, whatever it might be. They got latex allergy, for example. Well, you're not allowed to ask them that, even though they got latex allergy, they can't work in my plant because I'm making latex gloves. But I can't ask them that. Yep.
Is that why you typically see those in the job description?
Correct.
Of-
You're allowed to tell them
Yes.
what the things are so they can decide and self-select, oh gosh, I got latex allergy. I probably shouldn't go apply for that job. And so you can tell them what the requirements are. You can even tell them this job is a 50-pound lifting requirement above your head 100 times a day. I think, well, not too many people can meet that, but you can't ask them until you get there. And so the idea of the whole statute was, if I make the employer decide between these two candidates, who I think is right, they're close. I could defend probably either one. I think she's a little more qualified. I'm going to pick her. Well, if I was allowed to find out about the disability before then, I got two really qualified people, and she says, yeah, no, I think I'll be good. I'm still in physical therapy from the motorcycle accident I had, and I got a little bit of a permanent back issue, but I think I'm going to be good. What's a lot of employers going to do? They're going to say, I believe I'll take the other guy. He wasn't too bad. He didn't have that problem I got to deal with. I don't have to worry about a risk of a workers' comp injury, right? And the idea was that if you've already decided who's best, you're more likely to accommodate them if they need a restriction and they're able. And the rule's kind of interesting. Once you've made the conditional offer, it's kind of like you got to pass the drug test. Fail the drug test, you got a conditional offer, but you fail the drug test for the background check. Have a nice day. Once you've made that offer, then you can talk to them all you want about it. And the law is actually very protective of employers. If they can't perform the essential job functions, you can withdraw the offer. Hey, this requires you to occasionally do X, and you are not allowed, you're not able to do that. And so I'm gonna have to withdraw the offer. But the idea is that would provide the most protection employers, be the best about actually doing that. So there's some logic to that, but it causes a lot of weird things. And if you have people interviewing, you need to train them not to ask that stuff, because of course they want to know if the person can do the job, right? And you're going to work as a lineman for AP. You comfortable climbing up a pole, right? That's the first thing I want to know, because I tell you what, I wouldn't be, right? So, what do you do with that? And so you want to make sure you got people interviewing, you have any jobs that have sort of physical or demanding things or that sort of thing, that you're sort of talking about that. IP, we're going to talk a little bit about. That's becoming a bigger issue even for small employers, right? You have lots of things that are valuable to you. That might be a customer list. That might be the order history from a customer for last year. That might be what people pay for a particular product. That all different things so that you've developed that have value in your business, right? Give you some competitive edge. And you want to be protecting that stuff. And the requirements to do that are pretty specific. And so we're gonna come back to those in our next section, talk a little bit about that, because I think it's a weakness for small business to do the things that protect them. They're easy to do, but we tend to not be really good about having those processes in place. And the last is this idea of, are we training people about harassment and discrimination? You work for a big employer, they're doing it, right? You're doing it every year, whether you want to or not. We do it on video now, and they record them, and people got to watch them. They got to show that they went, and all this fun stuff. And small employers used to think, I don't really need to worry about that. But now with this state statute, you do. And that's part of the test to show that you have a good practice to get the benefit of that. You need to come tell me if you have a problem, is doing that training. Now, the good news is you don't have to do a full day seminar. You don't have to pay me to come in and put on some big deal and all that. You get no extra credit for doing a half day versus 20 minutes, right? It's just that you got to tell them what the rules are, what the expectations are, and who they should come to with a problem. Well, I can do that in 20 minutes pretty clearly, and say, if you have questions, and I give them a policy and say, read this and do all that. You ought to be doing at least that. It can be recorded. It can be something that you record. I've got a lot of small business owners that we've worked with them on a little script with their policy, and we just record a Zoom call basically of them talking to every new employee. And when you get the job offer, one of the things you're going to do is you're going to watch that video real quick, because we're checking that box right away, buddy. And so it's easy to do. And we want to make sure we're kind of doing those, but those are kind of low hanging fruit ones that I see getting in trouble. So now we're going to switch. 30 minutes, awesome. Yeah, I'm on track for time. Never the case. Never the case. So now we're going to talk about sort of more of the corporate business issues. And this is stuff that I hope does not bore you too much, which is why I did the other stuff first. But it's important stuff for your business that I think people don't always pay a lot of attention to when they get contracts. And I see terrible contracts all the time. They're great fun to litigate over. They're not fun to have when you're the person using them. Just taking other people's contracts and signing them. They were not designed for your benefit. If you take someone's offer and accept to buy a product and it says subject to our terms and conditions, you just agreed to all kinds of stuff. Did you even click and go to the website and see what it says? Most of the time, no. Now, if you're leasing a copy, are they going to change it for you? No. But maybe you want to know what you're getting into. But if you're buying materials, for example, or you're hiring somebody to do a job that has time sensitivity, right? If you're hiring somebody to do something meaningful, big companies have gotten really good at putting terms and conditions that are very protective, and you release them from all kinds of claims if they don't perform, even if it harms your business. Well, you agree not to seek lost profits. Even if I'm late and I breach this contract and I don't deliver the piece of equipment that you promised to your customer and you lose $100,000, not my problem. My exposure is what you paid me for the machine so far. Have a nice day. And that stuff's binding if you agree to it. And so That's the most common one I see. And a lot of times we don't have leverage. And I tell folks when you send them to me, we're going to do kind of a red light, green light analysis, because what I can do that's not helpful to you is I could give my associate red line this contract and make it fair, right? Protect the business or make it a good, fair contract. You're going to mark that thing up 15 ways from Sunday with a red line that looks like somebody bled to death on it. Well, they're not going to do any of that stuff. So pick your battle, even for big companies and manufacturers, when we're getting material from a supplier. Well, let's figure out the couple things that would kind of be deal breakers. And let's just write on there, we agree to your terms that accepts number 6 and 7. And if we initial that, and they initial that, we're good. We just didn't waive all our claims. We didn't just agree to go litigate in Alaska, right? And so you want to look and figure out what are the couple of things that you can reasonably ask the other side of the deal that's bigger than you to say, if you want my business, you got to be reasonable. I'm not agreeing to these 2 or 3 things that are crazy. And you're going to probably live with some stuff you don't like. But think about that a little bit. And I see people finding contracts that they think look good and using them. And a lot of times they're 80% good, right? But do you understand how they work? They have stuff that really works in there. And so I always tell folks, make sure you actually have the big things in there. It's amazing to me how many contracts I see that don't have a deadline for the deliverables. You think, isn't that kind of a key part of our deal? When are you going to deliver the truck to me? Because it's a big deal if I don't get it for an extra 3 months. And so some of those sort of things. Dispute resolution mechanisms are an important thing if you're the smaller party, right? If I'm a big company dealing with you, saying we're going to litigate in Michigan in federal court is great because I got all the leverage and I got all the money. That's a terrible situation for you. And so do you put some dispute resolution in there? Are we going to do it privately? Are we going to, they have to mediate with you? Do they have to do an arbitration that's private? What can I do to manage the cost, right? They have an obligation to have somebody meet with me to try and resolve it, or they're in breach of the contract. There's stuff we can do to make the little guy have a little more protection, right, in there. Make sure it's in plain enough English that we understand it. I see lots of ones where people have a contract and there's stuff in there and know what the heck it means. They read this force majeure clause, I don't know what the heck that means. And so be careful about kind of using the templates and what you do. Having a good set of terms and conditions of your own is a really valuable investment. They're not hard to do. You know what works in your business, whether you're providing a service, right? If you've got people coming in taking classes, there are things you're worried about that are risks that you want to manage. If you're selling a piece of equipment that somebody could claim product liability on, right? If you're doing a website for somebody and somebody might claim that you infringed copyright, well, how are we going to deal with that? Right. And so there are things in particular to your business that we can address really easily in stuff. And so we want to be thoughtful about sort of what we're doing that. These governing law ones are a big deal if you can do it. One of the most common ones, and sometimes you get stuck with it and can't do anything, are these places where you have to go somewhere else because that's really, really expensive. So look for those in agreements where you can get rid of them, get rid of them. If you can get them to agree to come here, even better. But you want to avoid this stuff where you've got to go to Michigan every time you have a dispute with them because they'll say, I don't care, I'm not going to pay you, come to Michigan. And that's their leverage. I don't owe you 10 grand. You're really going to come to Michigan and hire a lawyer, fly up there to try and get your 10 grand? Probably not. You're going to take 3. And there's people that do business that way. And so you want to make sure you're kind of protecting yourselves. Stuff that I see most common mistakes that end up resulting in, the law and venue one we talked about, missing integration clause. Who knows what an integration clause is? Okay. All right, this is cool. If you get nothing else out of this, look at your agreements. An integration clause means this is our deal, and you can't go back and hold me to something that was in the email when we were negotiating the deal 2 months earlier, or a conversation we had where you said you'd throw in the floor mats, right? It means this is our deal. That's it. If it didn't on this piece of paper, I don't owe it to you, and I can't make you do it. This is our deal. If you don't say that, then they'll allow, a lot of times it's called parole evidence, meaning somebody can say, oh, in our course of the deal, it was understood that that's what that meant. Well, that's messy, right? That's the kind of stuff that the person with more money can take advantage of, because now we got messy factual stuff that I can litigate over. So I want an integration clause. That's our 4-page contract. That's our 10-page agreement, nothing else. And as long as it says this is the entire agreement, supersedes everything else that's out there, that's what's called an integration clause. This integrates all our negotiations. This is where we ended up. So if there's something there earlier, it means we decided not to do it, not that we just didn't write it down. And you don't want to leave the mistake of, oh, well, it didn't get in there, but they always agreed that they come on site and do the training for free. Where the hell did that come from? And that's the kind of stuff we see all the time. Having terms in there that are meaningful but don't have any definition. I'll give you reasonable notice before I terminate the contract. What the hell does that mean? Well, I thought today was reasonable. You think like a month because I ordered all these parts. And so, we do see a lot of that stuff. Are there some basic agreements you ought to have? And these are going to vary a little bit depending on what type of business you have. So a customer service agreement, right? If you're a service provider, you ought to have some standard agreement that you're trying to get people to. When you go buy stuff from somebody else, you ought to have a standard vendor supplier agreement that you're going to use or propose. At least gives you some leverage to get changes. You may get stuck using theirs still. At least maybe you can get a few changes that help you. An employment or independent contractor agreement. What are you putting in an offer letter when you hire somebody? Or are you doing an employment agreement with key employees so that we get some of these other protections? So let's think about that a little bit. If I've got an independent contractor, boy, I better have an agreement because I want it to lay out as many parts of that test, right? So that I win if there's a dispute. Where you can set your hours, here's your deliverable, here's all the stuff. You're going to tell me that you do this for others. You're going to tell me all the things that help me defend myself if I get a claim over it. Confidentiality and IP assignment agreements. You ought to have a basic NDA. If you're going to talk to somebody about something in your business that you're planning to do, I don't really want them talking about that to my competitor. And if I go hire, whether it's a new marketing person, whoever it might be, I want to know that that's confidential if I'm doing something or looking at a piece of property. And so we have those out there a lot. IP assignment is an interesting one, and we're gonna touch on that next. That small businesses tend to miss, which is who owns the IP that your employee develops, whether it's materials, whether it's a website, whether it's some ideas for something, whether it's something they write up, whether it's something you design for a customer. You assume it's you 100%, and it's kind of you. But we want to make sure that we get from kinda to definitely you, and we have clarity on that. We'll talk about that. And then the last one that we'll come back to a little bit is if you're a business owner and you're not the sole owner, do you have an operating agreement or a shareholder agreement of some sort? It's incredible to me how many small business people started. They're good friends. They know each other, right? We go and do this. So we go file. We don't have a lot of money. So we pay someone $500. They form the LLC. They get us registered. We're official with the state. We got an EIN for a tax ID number. We think we're rocking and rolling. But we didn't really want to spend the extra $1,500 to a shareholder agreement at the time because we didn't have a lot of money. And we never go back and fix it. Or we have one that's just a boilerplate somebody did 10 years ago. And a lot of those, well, does it have any dispute? What if I don't get along with my partner anymore? What if my partner dies? Do I want to be in business with his kids? Maybe not, right? And so we'll talk a little bit about that, but looking at those agreements periodically to make sure they make sense and provide some clarity and protection. Disputes with your co-business owner are an ungodly morass. They're great fun to litigate, but they're really, really expensive. And if you don't have a good, clean agreement, you're just asking for spending a lot of money on that. So let's go to the detail on a couple of these. Trademarks, right? Copyrights, all that kind of fun stuff. You can put a copyright on something and say, this is my original work that I wrote, whether that's a website, whether that's an article you write, whether it's some marketing material you develop, whatever it is, training you do for a customer. And you don't have to spend any money. You just say, I'm claiming rights in this. This is my work, right? You put a copyright notice on it, and you can do that for all kinds of stuff. Think, okay, that's good. Trademarks, you gotta file. Patents, obviously, you got to do as well. And then trade secrets are kind of our other bucket. And so when we talk about these different buckets in something, you can get rights in a brand and a logo in a business by virtue of just using it and being out in the marketplace, right? And so I've been using CowanPerry in the marketplace here for years. If somebody opened a new law firm and called it CowanPerry, even though I haven't filed a trademark on the name CowanPerry because I think it's unlikely anyone's going to want to use it, I could actually go to them and say, if you're a law firm, you're causing confusion in the marketplace. I don't like that. If they said, oh no, I'm a Cowan and a Perry and we do farm services, we clean out barns, I probably can't stop them, right? Because there's not going to be confusion about that. Although I don't know, lawyers kind of clean up, and maybe there is. I don't know. But so you want to think about, so you build some rights, but you have a lot more rights if you file a trademark on your name, on your brand, on your logo. And you can do very easy searches. And actually, if you go to the trademark, the USPTO and trademark office, there's actually a really good search tool. And you can search and see what people are using close to your name that you want to use. You ought to at least be doing that, because it's really an uncomfortable conversation when somebody starts a great little business, they're having great success, and they come to us and they got a great logo, like all this stuff, and they say, all right, we're ready, we're finally doing great, made a bunch of money last year, we want to trademark all this stuff. And you say, yeah, that's a small problem. Some guy in North Carolina is using the exact same name for the exact same type of business as you, and he's had a trademark for 15 years on it. And oh, by the way, his market includes some of Virginia. You probably can't get that trademark. Or your name, the way you've done it, is too descriptive. They won't accept it. And so you've invested all this stuff in a brand that you can't protect. That you can keep using it until someone tells you to stop, but you really can't build brand equity and value that if you ever got to the point of selling it or doing something or protecting it. And so doing a little bit of that early, I think, is helpful. It's not hard to do. That database is really good. And you get close, we tell people all the time, just come tell us, we'll look at it. and figure out what do we want to do and what things do we trademark. It's probably not everything, but you might have a few key things that it's worth spending a little bit of money once you're at that point. And a lot of small businesses will say, let's look at it, right? We know you got to get making some money first. Let's make sure we think, at least as of right now, we think this is a name and a logo that we could protect for you. We do what's called a knockout search. There's nothing that clearly quickly comes up that says you can't. It turns out you cannot call your drink Coca-Cola. Sorry about that. And you think that's great, but you get down into there's pretty esoteric drink names out there, and you think you've come up with this amazing one, but maybe somebody's already got it. And so we can do a little bit of that and go forward when we get out there.
I had an experience with this where I ran a podcast for years,
Yeah.
and one of the fans of the show ended up trademarking the name specifically
Yep.
for clothing merchandise, and we were no longer allowed to make any merch with our podcast name on it.
And there are people who do this for fun, particularly if you do a lot of business on the internet, that go around trying to find people that have it, and then they'll trademark it for particular, because you can do for different purposes and uses, right? You have to describe what I'm trying to trademark this name for use in, I don't know, home building services or whatever it might be. And so there's a lot of that out there. So it's worth looking at that a little bit. Patents are more specific. Patents is I've created something new and I'm going to disclose that and say I was the first person to invent the wheel. So everybody's got to pay me a royalty if they want to make wheels, and I can show that nobody had a wheel before me. And so I'm going to disclose all the details of what makes my wheel special and new and all this fun stuff. If the patent office accepts it, great. I've got the light bulb. I've got whatever it is. So that's very specific and very expensive to do it right sometimes, but it can really be worth it depending on what your business is. If it's a tool, if it's a physical item. Software patents, very discouraged, a lot of that kind of stuff. And the big dance for most small businesses is between these last two. It's this idea of patent and trade secret. And so you can protect something by trade secret as well, right? You put things in place to make sure that you keep it private, right? It's on a locked server. You don't give everybody access to the code. You do all these things that show that you treat it as commercially valuable and only give access to those employees and people that have a need to know. And there's a statute that says if you do those things to protect it and you've invested in it, that you can protect that as a trade secret. And if your employee or somebody else that has a NDA or confidentiality agreement does something bad with it, you've got remedies under the statute, and they're pretty strong remedies under the statute. And so a lot of things, employers, particularly if the thing's moving fast and changing a lot, they'll say, I'm just going to rely on these trade secret and contractual protections because the patent I'm doing this year is going to look different in 2 years, and the cost, I'm not big enough to be constantly doing this mill of filing tons of patents to protect my space. Big companies do that all the time. That's how they push people out and defend, products that they're trying to develop. But for small companies, there's a real balance. If you've really got something unique like that, can be very valuable to do. I would tell you, depending on what it is, there's some folks that are more of a generalist patent person can do. If you're in something pretty specialized, the amount of specialization in that is crazy. The firm we work with up in Philadelphia, they do nothing but that. They've got a guy, all he does is fiber optic patents. Guy, all he does is plastics patents. And all he does is a mechanical device or medical device. There are people that's all they do. And if you get something that's got a lot of value, you want one of those people if you can get them. And so think about how you sort of protect those things as you go forward, and customer lists and things like that. If you don't take steps to protect them, you lose your protection under the statute, and then you can't stop somebody from using it. So if you don't password protect your customer list, if it's just on the server, anybody in the company can see it and print a copy of it, or you leave it laying around, or you have a price sheet that's floating around everywhere, you're gonna have a real hard time stopping somebody from using that if you can't show that you made some efforts to treat that and market and say, hey, this is right, this is proprietary to us. And that's why you see a lot of stuff, bigger companies, that they get better and have plans to do that. They're trying to sort of protect that stuff. So
with that,
yeah,
just using the chamber as an example, as a chamber, we don't release the information of any of our members. We don't have a running list that will send the mailing addresses, but I know other chambers will list that as a member benefit. They've got a PDF. With us, would that be a trade secret?
So it could be. Yeah, it's not. So generally, your current list and everybody's contact, that's an amalgamation that you've put together of information. It's not available otherwise. And if you treat that right as proprietary and do that, and some places do, you could license that to people, so it's the benefit, but you could make them agree not to share it with anybody else. And if you did that, right, then that could be a trade secret that you're sharing as a benefit for folks. And there are industry associations that do a lot of that, right? Where they say, we'll give you access to this database to go online and look for other people in this space, but you agree not to use it for certain things, not to resell it, not to do anything, but use it to operate your business. And you won't go, create a reverse engineer a complete listing, try and go sell it to somebody and aggregate our data and make you click through and sign stuff when you do it. So it can be, but you got to make some effort to keep it private.
And on that same vein, because I know on the marketing standpoint, you have to have people opt in to be able to send out
Correct.
email communications.
Yep.
So for the chambers that are putting that as a member benefit, saying, hey, if you are a member at this tier, you have access to send emails to this list. Is that essentially that's them opting in and that's
No.
what's protected? Okay. It's not.
Unless everyone that agreed to be on your list and become a member agreed to opt in for anybody that wants to send the marketing, then no, they still have the same obligation to get permission. The fact that they got the email from some lawful source does not give them the right to market to it unless that person. Now, if you made everybody that was a chamber member agree to that, well, good luck, right? But no, it does not. It does not meet that test and allow them to mass email all these people lawfully.
That's the I2P stuff.
I'm sorry.
That's I2P.
Mhm.
Yeah, we deal with that.
It's a big issue. It's become a space everywhere from people that are marketing prospective college students and how do you get people to opt in and how do you do that kind of marketing? How do you use that data when you have it? You have it from somewhere, got in there. What permissions do you actually have with it? I mean, it becomes a big.
So I have clients coming to me and then they have a big client list, right? They
Yep.
have this database of all their clients, but none of them have opted in.
Correct.
And now we have.
And they want to do a mass.
Now when I
blast.
market to them, and we
Yep.
have to get them opted in first.
Right. You have to send an opt-in email and most people don't respond to it. It's a real challenge. And
So how do you SMS them, right?
Yeah.
So I have the SMS.
Yeah.
But can I legally SMS them to opt in? Because SMS is more reliable than email now.
And you're gonna get a higher response rate for sure.
Yeah.
I think you can. Yeah, I think you can ask them to opt in if you've gotten it or they've had some business interaction with you without getting into trouble. Because I get some of those messages for sure. I mean, the reality is there's big companies and people being careful and making sure they're doing it right. And there's lots of people just doing it to try and get it out there and get moving and sending it out to those lists anyway. And know if people complain, then they deal with it. But that's risky. I mean, if somebody
Yeah.
turns you in for that, and you certainly don't want to be a service provider doing that for somebody else because you're taking on all the risk versus them just doing it themselves.
If you use SMS, I'm pretty sure that you have to also, they have to also.
Correct. They have to opt in for
they
the
have to
text
opt in
message
for
separate
the
from
text
email.
message, and you have to include opt-out language for the
Correct.
text message.
Yeah. There's a specific language you've got to give them. Yeah. Under that piece.
But to get them to opt in, if you already have a list, because normally now, I mean, the way we set it up is if somebody if they go to the website and they sign up or they want to be contacted, we have opt-in language there. And you make it required, just you opt in if you go through this. But if that is already this database.
Right. How do you reach back out to that list to get
because
permission?
email is not effective. You're not going to get
You'll get
lands in junk mail.
5% respond, and you'll get next to nothing. It's a challenge. You almost have to do it by SMS.
Yeah. And
you just have to provide that notice and take a shot at it and see what you get back, and figure out how you do it. If they're actual customers, you can get permission other ways and customer agreements and things like that, and have outreach where you do it a little bit better. But it's a big challenge, and there's a lot of non-compliance with it. That's the frustrating part, is you talk to somebody and you got people not doing it correctly, and you're trying to tell them what they actually have to do. And well, wait a minute, but I'm getting these things all the time that I'm not opted in for. And say, well, yeah, technically, but they're not proper. So we talked a little bit about trademarks. I'm not going to go in a whole lot of detail there, but think about that. If you sell internationally, that's a whole different level of sort of compliance. The trade secret stuff, marking it, actually having your employees agree either, right? And you don't want to put that in your handbook, right? You want that to be, people have these confidential things in the handbook. You just did a disclaimer and said that's not a contract. Well, the NDA, I want to be a contract. And so I want my employee to sign a non-disclosure agreement.
Can I ask you something from the previous?
Yeah, absolutely.
Just, I have a few trademarks
Mhm.
registered nationally,
Yeah.
not international. One of them, and it's a phrase. It's not a logo.
Right.
This one, it's just
Sort of like a service mark or something.
yeah. But the identical one was trademarked in 2 different countries by 2 different entities.
Yeah.
Okay. Now this product is on Amazon.
Yeah.
So I believe I own the Amazon.com
Right.
ability to use that trademark
In the US. Yeah.
in the US.
Yeah.
Right.
Yeah. Now if they log in on the Ireland version, maybe they can do it if you don't have
Correct.
rights there. And then, and if you get these foreign ones, then, if you want to fight it, you got to show that you were using it in that market before they did it and all that kind of happy crap. And otherwise they may own that market for that phrase or that product description.
If it's registered?
If they register it in Canada, for example.
Oh, yeah.
Yeah.
But now what's happening is I have a company from Australia
Mhm.
that's putting a product on, and they don't use the phrase in the description, but they use it in video.
Mhm.
So that it's verbally used.
Still counts.
Okay.
Yeah, you can still send a letter saying, stop using my phrase or pay me a license to use it. Yeah, I own the rights to that here in this space. And I think you're violating that. Yeah, it doesn't matter if they do it in a commercial or a video they send to clients, it still counts. So,
Okay.
but it's an interesting area.
That's like the guy who trademarked the three-peat phrase, right?
Yeah.
Gets paid every time someone like with the Kansas City Chiefs, when they were potentially a three-peat for the Super Bowl, every time they used it, he gets paid.
There's some interesting ones people have gotten, and whether they're defensible or not, right?
Right.
You get into some of that. So talk about our employees and kind of doing things to make sure that we, do we have something where people are agreeing to return stuff to us when they leave or not keep copies of our information? That's real nice to have. If you're trying to take action against somebody who's using your customer list, listing your clients, all that fun stuff, one of the most effective ways to get a court on your side is be able to show, hey, we had a thing. They promised to not keep copies of any of this stuff. And guess what? They emailed it to themselves, right? Before they left. Happens all the time to people. They put a drive in, they made a copy of it. People don't always do it the smartest way for reasons I do not understand. But all the time, that's a big deal. And if you have them agree to do it and they don't, then that's really good. And if you get into more sophisticated stuff where you have a lot of IP, we actually have people sign certifications of good faith they leave, that they've given everything back, they haven't signed a copy, they're going to comply with their agreement. And we do that because to go in and get an injunction, you have to show actual or likely misappropriation or use of your information. And if I've got an agreement with you and you refuse to sign this thing when you leave, saying, I quit, I'm not signing shit for you, I can go to the court and say, wait a minute, when I hired them, they agreed to provide this certification when they left and to do these three things. Now they're refusing to sign, saying they're going to honor it. So Judge, I want you to enjoin them. Now you have a likely to believe they're not going to honor their obligation, because it's often hard to prove. You don't have the evidence yet. And so how do you get them enjoined on the front end quickly? And so having some of those sort of agreements are awesome if we have to go stop somebody who's really sort of hurting your business. So think about those, right? When you have these IP agreements, ownership of work product is an interesting one. The place that we see, so generally speaking, if somebody's your W-2 employee and they're doing something for you, right, then you're going to own the rights in that, right? If they do a website for you as your employee, right, then you're going to own that. So how do people get around that when they're doing stuff? Well, I incorporated something I designed before I got here. Well, that's kind of problematic, isn't it? What do we do with that? If that's true, maybe you don't own those rights. They give you a license to use it, then they tell you stop. And we've had this come up with websites, with PowerPoint, with models people have built in Excel and financial businesses, all kinds of different stuff where people say, well, I brought that with me. And so if you're in a business that IP is meaningful to you, one of the things we do in our confidential IP assignment agreements is you give me a disclosure. Anything related to my business that you've developed before that you're not giving me the right to use, tell me about it now. And of course they say nothing, right? And then you don't have the problem. And so doing those things can really provide a lot of protection, because we've gotten into those sort of issues here and there over sort of ownership of work product. Same thing with an independent contractor. What do you actually have the rights? Do you have the rights to use it, or do you actually own it? Did they give you a license? And a lot of times when people get websites designed, it's very common they give you a license to use it. Well, it means if you violate the license or aren't paying them, they tell you to stop. And then a number of small businesses have had the ones where they want to switch and they say, oh no, we own that website. We just license it to you to use it as long as we were hosting and you were paying us $250 every month. And they go, what? Well, read your contract. And so you want to make sure you own that. Once I pay you, I want to own it. And so those kind of things on IP, and you hire people outside to do some marketing or development work, you want to make sure you own that stuff, and that they're telling you that they own the rights to everything they incorporate. That's the other place you get into trouble, right? I hire a vendor to do, whether it's a website, whatever they're doing for you. And then somebody later comes back and says, well, wait a minute, that's ours. And it's something that your third-party consultant did. And you say, well, oh dear, have they agreed to deal with that? Have they represent that they own that IP? Have they assigned it to you? Have they said if there's a problem, they'll fix it or get you a license to continue using it? And if you have machinery built for you or all kinds of custom stuff, that becomes a really, really big deal. So we want to be sort of thoughtful about some of that.
Where it mentions created on the job.
Yep.
So example, if and for Steve, listen to this later, I'm not gonna sue, don't worry. So if I'm at home working on Adobe that is paid by the chamber,
Right.
but it is on my own time, if I create something on there, is that owned by the chamber or owned by me?
So it's an interesting question. So if I have an agreement with you that says anything you do using my tools and resources, I own. Now, generally, those can be overbroad and become unenforceable if you get kind of crazy with it. So generally what they say is if you use any of my tools, even after hours, even if your laptop, use my laptop, use my software, use my license for, Adobe Creative Cloud, whatever it is, if it relates at all to my business, I own it. Now, if you do a thing for your church, I don't care, right? That doesn't relate to my business at all. But anything you do related to my business, I own. Anything you come up with. And you can do that if you have them agree to it. If you don't, you may have an issue with them misusing your resources, but you probably don't own it. It's kind of what ends up happening. So risk management is always a big thing for me, right? If you're getting in a business relationship, what do we have in writing? Insurance, not that expensive to get even for a small business. Employment practice liability insurance is worth looking at now that small businesses are much more subject to those suits in state court. Insurance for that is called EPLI, Employment Practice Liability Insurance. And so you want to ask if that's available as a rider. Oftentimes you can get that pretty cheaply if it has a higher deductible than your regular policy and has some limits, but it's really, really nice to have. And so, for example, what you're trying to do is protect the suit where somebody sues you for $1 million for discrimination or whatever it might be, or failure to hire or something that, right, you may pay the first 25,000, but up from there up to 150, you got an insurance company picking up the check, or up to $1 million, whatever it may be. If you get that designed right, you can take the risk that you can stomach, right? The employee just leaves. I got to pay him 10 grand to settle, get rid of it. I'm not worried about it. But the really big thing that's expensive as can be, I got insurance company paying the lawyer, and I've got some funding there to protect me and get that settled. But I have a much better likelihood of an outcome. The other is what's called commercial general liability. That's the regular stuff that comes sort of day to day in your business, where a vendor or somebody sues you that your product was defective, or you misrepresented something, or you did, those kind of things. And so you want to look at what you've got there. The cyber insurance is an interesting area. You got to look carefully at those policies, right? What if somebody bricks your system and puts you out of business and you have a business interruption loss? Do you have coverage for that? You can get those riders. They're becoming much more specific about what you have to do to qualify. Like we have for law firms, we got to rep certain type of systems and protections and what we do, and they right to audit you, and you have to adopt certain policies and have to use dual authentication everywhere. And then if somebody didn't use it and you didn't make them use it, then guess what? They don't have to cover you because Molly didn't use her dual authentication, and that's where your vector of attack was, and your system got bricked, and they say not a problem. And so you need to be careful with those, but they can be incredibly valuable if you have a good one. So think about that stuff. That's about sitting down once a year and talking to somebody. My favorite way to do it, because I always learn more, is to have lunch with the client and either their banker, if they're in a business that they deal with commercial banker a lot, or more often their accountant, because the accountant knows all kinds of stuff that's going on that I don't know, right? And payroll issue, whatever's happening is dealing with all that stuff. And we can sit down and let's just talk about what we're doing in the business and say, what are the risk things, right? That might be there that we want to think about for next year. And I think doing that once a year is a pretty good investment of a meal, I think most of the time. The other is this idea of these agreements that you have with people you're in business with, right? Do you have a right to buy your partner's family out if they pass or become disabled? How are you going to value the business? That's where a lot of the fight a lot of times is. Are you going to fund that with insurance? A lot of times that's pretty cheap. If you and your partner aren't really old, you can get that insurance really cheap. We have that at our firm, right? If I get hit by a bus when I walk out of here today, well, that's going to be a pretty big hit to the business. It's going to be hard for them to hire and recover. And so they'll have a bucket of money to buy my share out. Because what happened is the day I get hit by the bus, the company's worth less, right? Because I'm bringing a lot of revenue and right, I'm a big part of the business. And so, but now also like where's the money come from to pay my family for my shares, right? They don't want to keep giving them half the profits of the company forever. So what are we going to do here? And so we have we have insurance that covers that risk. Both provides working capital to the firm and then also provides a bucket of money to buy out my interest in the business. And so nobody has to worry about it and really takes that risk off. And that kind of insurance is pretty cheap because it's usually term insurance, right? You don't need it forever. And so that's pretty good. Or coming up with some way of how you're going to value doing these things. Do you have restrictions on somebody selling your stock to someone else or borrowing against it? We've had some really messy situations where one partner or the other is having financial issues or whatever it might be, or marital issues. And next thing you know, they've transferred or they've leveraged the stock and somebody else is foreclosing on the stock because they borrowed money and pledged stock in your business as collateral. That is a really awkward conversation to have with your business partner. Have been a lawyer involved in that. It's not, and it's real hard to undo and fix, right? And you end up having to fix their problem, and that's not a situation you want to be in. So thinking about those sort of restrictions and those kind of things in your agreement, they're really easy to put in place. But so many really successful businesses start out right with an idea and a lot of hard work. And that's, you're not spending your first 6 months of running your business in my office or you'd be out of business, right? And so when do you come back around and pick up some of that stuff?
Just one note on the buy sell is a lot of, we work with a lot of businesses and we help with buy sell structuring.
Yep.
And I can't tell you how many times we meet with a business that has the buy sell implements in place and not the actual agreement.
All the time.
So just make sure as a business owner you have the agreement as well as
we see ones all the time, but show agreement talks about the buy sell agreement. Nobody's ever signed it.
Yeah.
Says there's going to be insurance. Here's how it's going to happen, but nobody ever bought the insurance. All kinds of things that are like that happen all the time, and it becomes a big sort of issue when you're out there. And then at some point, succession planning become an issue. Like what, if you have a business that's substantial, is how are you going to have it continue after you, right? Maybe your family members aren't running it. Maybe they are. You're going to sell it. What are you going to do? Do you have insurance so that the taxes on that don't force them to sell the business? If your business becomes large enough, that becomes a big issue for some of our clients that have been blessed to have really, really successful businesses. Because at some point the government's going to want to share that if they haven't done any planning. And we've had people have to sell, businesses worth $50 million because they didn't have money to pay taxes that we're doing. Nobody did any planning. They didn't expect the person to drop dead. And guess what? Now we have a problem. And those, you can get insurance for that risk as well. There's all kinds of stuff you can do with trusts and wills and all those kind of fun things. And the other is, have you trained to have a succession plan? And there's two ways to think about that. Right. One, you care about your employees, right? You're on a job. If something happens to me tomorrow, I want to know that my employees and their families are still going to have a business that can take care of them and move forward. And so that's important, because how do I do that? The other side is, if you want to sell your business at some point, and that most business owners, right, in a lot of situations, they don't have a family member to take it over. They don't have a partner buy it, right? It's, I own the business. And at some point I'm going to sell it because I need to quit working. And whether that's a health issue or I just decide to retire, and then I go to sell it and have someone come in and try and value the business, and I haven't done any succession planning, right? So they look under the hood, things don't look real good. I haven't been training people to take over the different jobs. I haven't been doing things that show them how the business is going to have the same value without me there in 6 months. And so they'll only buy it if I agree to stay on another 2 years. Well, I really want to do that. And so there's all kinds of things where you get to that point where you've been successful, particularly if you're the one who owns it and you don't have some other very clear idea of what your pathway is. Sitting down and making some of those plans. We just worked with a client that we represented for, gosh, I think we first started doing work for them in 2003. Of all things, they got sued in Virginia, ended up buying another business here and had a very successful business. And the owner thought about selling it from time to time, could never get, kind of cold feet, hard to let go of your baby, built it, he'd run it forever. And we really had to get serious. We initially tried to sell to a large company, wanted to buy it, and they started looking and they're like, well, these people locked down. You haven't done the stuff you needed. He's like, I know you've been telling me to do that, but right, we get your key sales guy. He's not subject to a binding non-compete. All he's got to do is move to California and he can take your whole business with it. Well, that's a problem. Maybe we need to tie that guy down a little bit before we go sell the business, right? Who do we have in these other roles? Do we have our vendors locked down? And so one of the things that we spend a lot of time doing, and it's interesting, we do it a lot with tech companies that have been successful that are selling earlier. We do it with a lot of businesses that people have owned them forever, is let's sit down and say, if I was the buyer coming in, we'll do an audit and come in and say, what things would they want to see about your business? That because a lot of times the people will get an offer. I'm going to pay you $10 million for your business, and it's in an LOI, right? And then they say we get to do some due diligence and make sure the business is good and the revenue is what you tell us it is. And what are they doing when they do that? They're also looking for places to get that price down because they'd really like to buy your business for $5 million. Because 10's a lot if you can get it for 5, right? And if they're going to come in and find all these other issues, well, some of your contracts aren't assignable. So we don't know if we get to keep that contract. So we're not going to pay for that one. None of your employees are locked down. So that's a problem for us. I'm going to go through all these different things about your business. You don't even have minutes and stuff. Yes, as a shareholder, and he left. And yeah, I know you never got a stock certificate back. Right. And you have all these different things, and all of those things are things that ultimately impact the value of your business. You don't have good policies, you don't do training, and you want all that stuff to look really good when they come lift the hood on your car. And so we try to spend a lot of time on that with owners when they've been kind of successful. Obviously, there are times where you might want to, come talk to your friendly neighborhood lawyer on the front end and talk about, kind of some of those key things that are issues, right? Buying a building, we're bringing in a new investor or partner, we're borrowing money and we're pledging the company's assets as a collateral for it. We're going to do some sort of credit facility that pledges our AR. Well, how do we get out of that if it doesn't work and break the cycle, right? We've got a big customer, employees, all those kind of fun things. The government calls you probably ought to talk to someone. And so all that stuff are points where sitting down with somebody and doing a little game planning is going to have a lot of value. So, obviously my view is to try and be as proactive as you can, try and find people you trust. My view is doing this business very long and you don't have a banker that you really trust and rely on, and you don't have a really good accountant that's responsive to you, and you don't have a lawyer that you can run a question by that'll call you back, then you probably need to start working on those three things as part of your plan for the next year. So those are kind of my thoughts on stuff that might be, hopefully some of that gives you some food for thought of things you can do to make your business a little more defensible, protected, safe, valuable, whatever, all those fun things in the coming year. Anything we can help with, let us know. We'll try and find the right resource for you if we can. And we enjoy doing this stuff. So I appreciate you taking the time out of your morning to come listen for a little bit. And I'll stick around if there's any questions. Also tell folks, and if you're on video, if you're not comfortable asking a question in the group, if it's related to anything we talked about today, call me, send me an email. I'm happy to chat with you about it as part of what we do with doing the program and sharing. I mean, we don't do marketing for our firm. We get people all the time wanting us to do it. Our only marketing is people referring business to us. And so anytime we get a chance to talk to somebody and maybe convince them that we actually have some expertise in what we do, that's the best thing in the world for us. I tell every banker I deal with, you got somebody with a question, get me on the phone. I'll talk to them about their wage hour issue, right? They got a letter, they got an audit from DC. What do I do with this thing? I got one of these appeals. That's the best marketing in the world for me, right? And so anytime you or anybody has an issue, we're happy to have some initial conversation and see what that looks like and do that. So appreciate it very much. And any other questions? We got great ones during the session. So thank you guys.
Present this to you. Thank you, Jim, for doing this.
Yeah.
Enjoy your chocolate and coffee.
All right.
I want to thank all of you for being here. Thank you for being online for those folks. A reminder that we do have that HR small business workshop in August. In September, we have one on SWAM certification. And we have our golf tournament coming up. We still have some AM teams. So if you want to come play at the golf tournament, please sign up and do so. But that is it. If you have any questions, like you said, you're here. If after the fact, those online or you in person have something and you want to send it to Jim, go ahead. If you send it to me, I'm happy to get it along to Jim. The chamber will charge a $25 an hour just on top of his rates for that service. But thanks all for being here.